Welcome to Fire Service Court Video. And with me today, my name is Brad Pinsky, and with me today is the Honorable Curt Varone and the semi-questionably honorable, but soon hopefully to be very honorable, Chip Comstock.
Yeah, hopefully very honorable, Chip
Very
Comstock.
honorable. I can't believe we could possibly, not to jinx anything, call Chip Judge. So anyway, it's the judgeship. Anyway, so today we are going to talk about a hot topic, and this is such a big topic. I think there are cases on it, my God, every other month or so coming out of the courts. So today's hot topic is going to be facial hair in the fire service. And yes, everybody probably knows the basic rule. Oh, you got to be clean shaven, no hair growth. But there are so many issues. And we have a recent case we're going to open the door with. But Curt, let's go to, or Chip.
Well, before you start, I'm beginning to think maybe I'm not qualified to talk on the subject of hair.
Well, this is not topic hair. This is facial hair.
It's either
Hair
one.
is
I got
hair.
to pull out my 25-year-old beard pictures.
You know, as I look at our video to the viewers, I look at best, okay, and no way in hell. So if anyone's curious, this is the, best, okay, no way in hell look. So Curt, why don't you start with the case that just came out, great decision, and let's kind of start with that as one of many examples we'll talk about today.
Yeah, so we have a firefighter in Atlantic City who he claims for religious reasons it's a requirement of his beliefs that he have a beard. And so Atlantic City has a clean-shaven requirement. I'm not sure if they allow mustaches, but they have a clean-shaven, certainly at the interface. And we know that OSHA and FPA, and certainly the research arm of the federal government, NIOSH, has concluded that you can't have facial hair at the interface for safety reasons. So,
and Curt, how old is that research? How old is that research?
It's got to go back, and I can't say accurately, but my sense is it goes back to the 80s. Okay. So maybe even earlier, but it's that'd be last century's 80s, not 1980s. So, and so the question becomes now he's a veteran firefighter, and since I think around 2015, he's been assigned to really a non-line position in administrative. He refers to it, or the case refers to it as an administrative position, as an air mask technician. So my sense is he repairs SCBAs. He's also responsible for, I'm sure, filling bottles, and then whether he has responsibility to respond with the air supply unit, get extra bottles there. I'm assuming that's part of his duties as well. Bottom line is he hasn't had to go for a fit test and hasn't had to wear an air pack since he's been in that position going back to 2015. So he sued alleging that it was religious discrimination, that he had this religious belief, that it was burdening his religious beliefs. And in addition, what he was alleging, if it is indeed religious discrimination, the courts would apply a thing called strict scrutiny, which very, very rarely is a governmental requirement going to get around strict scrutiny when it's applied. And strict scrutiny is applied for race and gender and religion and ethnicity and so on. Now, there's another rule out there called the general applicability rule. And under general applicability, as long as you have a race-neutral, gender-neutral, religious-neutral requirement that is applied to everyone in the organization, it's not applied only to specific religions, specific races, but it's applied generally, such as a clean-shaven requirement, then you can have those kinds of requirements. Okay, so now we've got this little question about whether or not it's going to burden the fire department to allow him this accommodation to have a beard because he's in this administrative position. The district court, and that's where lawsuits start on the federal side. The district court ruled in favor of the fire department. And that's consistent with cases that we've got from, 8 or 10 cases over the last couple of years, as you mentioned, that are all saying, look, OSHA says you need to be clean shaven. NFPA says you need to be clean shaven. The research from NIOSH says you need to be clean shaven. The manufacturer says you need to be clean shaven. No hair at the interface. You got to comply with it. So the district court went along with those rulings. The case went up to the Third Circuit, and that's why I'll turn it back over to you. The Third Circuit said, yeah, not so fast.
Okay,
I'll
so right.
continue if you want, but,
No,
you know.
no, that's okay. So we have, right? So we have the Third Circuit saying, hold on. Now, here's the problem we have, and that let's kind of back up a half a step. We have the fire protection class, which goes into fires, right? And there's no question they need to be clean shaven. No one's disputing that in this case. But here we have the guy who tests services the SCBA, the guy who actually fit tests others, who presumably, at least the court says, is not in the fire protection class, so doesn't go into fires. So the big question is, why then should this be applicable to this individual? How do you terminate this individual for not complying with a rule that he really doesn't have to comply with? Now, this is the big key to this case. If this individual could be called for overtime or, assigned to a fire truck as part of his duties, this would come out differently because he would be in the fire protection class. But the court here, summarizing, says because he doesn't engage in fire suppression, then he is not included in the general class of people. But here's the other thing the courts look at. Who is and who is not required to wear a mask? Remember, in a fire, remember what Curt said to everybody listening is you've got to have a generally applicable, right? A rule. So it applies equally to everybody, and everybody has to be equally affected and equally obligated. So in other words, if it affects me, but I never go into fires, right? But I'm in the same class as Curt, who does go into fires, is that reasonable? Is that not reasonable? So I just got off the phone with somebody, I won't go through it, who said, well, we have a group of people who never go into fires, but they could become they could get into the air, right? And they could be, and we're going to spend a lot of time talking about volunteer vehicle operators later after this, but really, you could, if you could get into a hazardous environment where the air quality requires you to wear a mask, okay, then you'd have to be part of that. But the court looks at what job class was this person in? Who else is in it? Who else is affected? I think everyone would agree a mechanic who is never going to be mandated onto a truck, never going to go into an IDLH environment or a near one, is only going to stay in the garage, right? That person does not need to be, right, compliant with 1910-134.
Well, there's other critical part of this case, though, is that when we get into these arguments about wearing beards, not having beards, and your job performances, the underlying thing that we haven't discussed is the reason for wearing the beard, right? It's not just I'm being a pain in the butt, I don't want to shave. The folks in all the cases have brought the lawsuits for on the theory that there's a underlying religious basis to have the beard.
Right. And we should talk about the exemptions. But before there's any exemption, what my advice to people is you better figure out who's really required to wear a mask and not required because, we feel it's a good idea, required because it really makes sense, right? You really have to do it. And by the way, I'm sitting in like a construction zone, so this is going to get bad. So I'm going to turn off my microphone and turn this back over to you guys.
Is Nicole out there with that saw?
I heard a saw running in our living room. Yeah. Right. So let me turn it back over to Curt so I can mute my microphone for a moment.
All right. Well, the court applied strict scrutiny because they were able to conclude, and I personally disagree with the way the court came out on it, but the court concluded that there was a couple of different rules and policies in place that indicated that it was the no beard rule was not generally applicable. Okay, and even though they're policies, and I think this is an important lesson for all fire departments, you should have a rule that says all uniformed firefighters unless you're a civilian, if you're a member of the fire department, you're a uniformed firefighter, you need to be able to wear an air pack without exception. Then that gets you out from under this. But he was able to show that he had not had a fit test since 2015. So that was kind of issue number one.
Despite the guy, he's the one who administers the fit test. Right? He's the one who administers the fit test. And he give himself one.
Right. Well, he should have a boss, and the boss should be saying, hey, why didn't you do you should have had yourself fit tested, by the way. But they failed to do that. So that was sort of issue number one. The other issue was...
That's how they should have fired him, right? You didn't give yourself a fit test.
So the other issue was that there's apparently a rule, which I get, a rule that allowed captains and I think incident commanders to make a decision that folks did not have to comply with the mandatory mask rule. Now, I don't know any of the, inside the dugout kind of baseball, what's going on in the Atlantic City Fire Department. But my assumption is that rule is applicable at a fire once it's been knocked down, and we got to make a decision about, okay, guys, you can take your masks off. My sense is that's probably where that fits in. The court, I think, misapplied that and said, well, if captains can allow people to disregard the mandatory mask rule, then it's not a generally applicable rule. Therefore, we're going to apply strict scrutiny. And again, we've got usually, with Chip's exception here, but usually we have non-firefighter attorneys arguing a case, okay, in front of a judge who's not a firefighter. And they don't understand the relevance of that and how that policy fits in. And the result now, the court reached the conclusion they probably wanted to reach, that, we're not going to mandate that this man have a clean-shaven face.
So if we can...
I think the argument would have been that the deviation is permitted when it's determined that it's not a IDLH atmosphere, right? So if we say it's a mandatory mask rule for an IDLH atmosphere, but if based on monitoring of the atmosphere, we determine it's not IDLH, then the captain can say you can take off your mask at this point. So we are being consistent.
But that raises an interesting question, Brad. We all of us talk about this. Let's say the fire department realizes, okay, now you've got to have a fit test. Even everybody's got to have a fit test. That's number one. And number two, we're going to adjust the policy that Chip, you're just talking about. Is that retaliation?
That's a big question, because people are always wondering, how do I fix a problem if I go back? Is it retaliation, or am I just fixing an oversight in our processes? So can I give you a hypothetical right on that? We're going to bounce all around today, but this is such a good topic. We missed John. Sorry, John, you're not here. So let me give you a topic. So we have Fire Department A, who says, okay, we have a rehab team who goes in and they go to the scene. We don't train them in SCBA. We don't give them access to SCBA, but they could be required to wear SCBA. What's that?
Sound like police officers.
Yeah, well, no, they just run in and, with a fire extinguisher as part of fire out. But they could be required to wear SCBA. So let's assume they then call us and we say, wait a minute. You can't fit test someone and say you fail because you won't be able to wear a mask if we don't even give you access to a mask and don't train them in an SCBA. Because once you say, oh, we require you to wear it, but we're not giving you one, you violated the other portions of 1910-134. But so the question is, and I'll withhold my opinion, can we now go back and correct that issue and say, okay, now we're going to give you access and we're going to give you training on how to use it. So in the event you need it, you now have it. So now your religious exemption for wanting to wear a beard, it's gone. You have to be clean shaven because while on scene doing rehab, you might be, in the bad air area. That's a separate issue. I know people are going to say, oh, why are they there? But skip that one for a moment. So what do you think? Can we correct that problem, or what do we do? Chip, who's deep in thought reading this case?
Well, again, I think it goes back to issue one. I'm not so, when we talked about the two deviations, one being the IDLH atmosphere and giving the captains the discretion, I think by having a policy, I think that one makes it. The issue on the retaliation, and Curt, I assume you were thinking about you now have to wear a mask because we're going to go through all this just as you described. It certainly seems we're changing our entire policy there for one person, right? If it's one person, it does start appearing like it's retaliation. And I think you'd have to be really able to say, oh, this is why you need to have to be using an SCBA. But he hasn't had, up until now, after all these years, there hasn't been any evidence of that fact in this case.
That argument was made in the FDNY case. Several African American firefighters said we have functioned fine for 4 or 5 years. Okay, and I go back. I've had to argue this in cases. My grandfather for 50 years refused to wear a seatbelt. Does that mean not wearing a seatbelt is safe? No, it just means he got away with it. It doesn't mean it's safe.
That was the point. And you're talking Bay versus City of New York, and that was the point in that. OSHA had just come out with their new opinion letter, which said 24-hour growth is no longer acceptable. You have to be clean shaven. Some of the black firefighters had to shave now once, twice a day. It was causing them irritation. And they said, we have a medical reason, some religious reason, but I think Bay was a medical reason, I think, couldn't shave that often. And so they're differentiating Chip's point. That was because OSHA came out with a new ruling like you're using with the seatbelts. We're now going to change our policy. As opposed to just one person, we're changing it because now you've complained. It does seem like it smacks of discrimination, does it not?
It's something that I think you've got to be prepared to show that you had a reasonable basis for the change. Right. But I think anytime you're responding to something like that, retaliation's on the table and you have to be careful.
So
there was the other exception here. Wasn't there an exception in this case that you didn't have to shave if you were coming on a callback, right?
Really?
Oh, I thought I had read that.
I might have missed that.
I don't remember seeing that.
Which kind of gets interesting too, right? Well, okay, what is the level of you're either clean shaven or you're
absolutely.
not? Right. I thought that was
shave when you get there.
Potential.
But that really goes to the question of, is it a real rule or not, or right? Or are you enforcing it? But okay, now let's change this. So now I want to change this, but I want to go back to my rehab thing, and I'm doing this for a reason. It's not one person you're going to adjust the policy for. We're going to change it for the entire class of rehab people who go to the scene, albeit they're mostly in the cold zone, right? But it's now a class of people. Yes, one person complained, but we're going to now change it for, let's say, 20 different people. I think that's a factual analysis, right? That makes it seem less retaliatory. Would you agree? Or are we still retaliating because we're going to address all of them to mess with the one?
It's still only, you got to look at how many people are impacted. But I think in a fire department, and I'm assuming Atlantic City has their own fire prevention division, one of my questions would be, do you have uniformed firefighters staffing fire prevention, number one? And number two, do they have to undergo the fit testing? And again, I go back to the Marine, and Brad, you and I have talked about this. The Marine approach is that every Marine is a rifleman. And even the commandant, a general, has to qualify with his rifle periodically, whatever it is, annually. Okay, so now if that's the case, and you can live with that, if you say every firefighter is a firefighter, regardless of rank, and you have to be, doesn't matter if you're in fire prevention, the training division, you have to, if we have a general alarm fire, you've got to be able to put on a pack and go to work. And if you're not, then maybe there's a light duty position or whatever, a temporary position that we can have for you. But other than that, you're expected to be a rifleman. You're expected to be a firefighter.
Ohio has, the rule in Ohio is any employee who the term is may, have to use an SCBA, is required to have an annual fit test, is required to not have anything interfere with the seal of the mask, and has to have an annual and has to be certified medically on an annual basis. So those are three of the rules, and it doesn't say who's going to or his job duties. It says who may be subject to using SCBA. So that person who's in the rehab area and the wind shifts, right? You may have a problem.
And Brad, with your medics, you've got an issue with the negative pressure, just the filter mass, the different
But there's
filter
an
mass.
accommodation,
So,
right? The papper, you could wear a papper or whatever, right, to cover the beard. And there at least is a reasonable accommodation that could be made with EMS.
yeah.
So let me throw out the hardest question. Okay, volunteers, get ready for this. This is okay. The volunteers are going to love me, but I'm guessing they're going to hate at least one of you. So a lot of volunteer fire departments,
Well, the fact we're lawyers, I figure there's an equal chance of that already.
Fair, but I just
we're
want to
on
back
Dante's
right
8th level of hell to begin with. So
no one likes
that's it.
lawyers. So here's the very realistic scenario, and it's truly, it comes up all the time, and I feel like I switch my opinion every so often. But now in the volunteer world, in many volunteer and combination departments, there are a position for operator only, and so they only operate the aerial, they only operate an engine. Right now, you can't add more ladder. So we know that 100-foot aerial is going to be like within 68 feet or so of that building, right? And clearly could be within the smoke or fire. The engine, wherever you park, but you still are likely going to be close to that fire. So you could, the Ohio state law is you could be in the ideal H or in a hazardous air quality environment area. But many volunteer fire departments allow this to drive. They allow the beard to drive and operate. So here's my question. Do they, I have three options, maybe you come up with more. No SCBA required, SCBA required, or will allow you to have a beard, but you can press it against your face to create the positive pressure seal because you're not crawling around in a building. What of those three options work?
Honestly, what is somebody that isn't prepared to put on a mask and you have a fire, or God forbid, I've been to some crazy incidents, but none like Chip's railroad tanker explosion.
Well, that's where I was going.
And you're gonna be running for your life. Run for your life.
3 mile
Brad, you bring up the house. You bring up the house fire. How about you're going to the motor vehicle accident? You're driving the rig to the motor vehicle accident. And it comes in as we have a motor vehicle accident, car on its roof, people trapped. What they're not telling you, so people are jumping on the rig, and they don't tell you that the accident's with a tanker truck that's got methyl ethyl death in it or something else. And I don't worry as much about the structural fire cases as much as I do the hazmat incidents.
Yeah. So your rule, you would say everybody wears SCBA.
And another issue, and this is, to the folks out there with beards, with due respect, okay, if you think you're going to be exterior only, okay, you're running the pump, and there was just a video that was going through social media on this, where a porch collapsed. Firefighters were trying to advance into the building. The porch collapsed, and all these civilians start running to. Are you telling me you're the pump operator? You're just going to sit there and say, "Wow, I'd like to help. I'm going to watch all these civilians go in there and help." If you're going to be going to a fire, you need to be SCBA proficient, period.
Look, I remember one of the calls I went to, our engine pulls up. It was a house fire, single story, residential, not fully engulfed, but heavy smoke. And the operator of the engine, our first due, only had one place to park. The smoke was so bad, I get out of the truck, I can't find the house. I was totally disoriented. Like, where did the house go? The operator is literally trying to feel the pump panel. And, everyone could question, why did he park there? Right. But the wind shifted as we pulled up, and that's what happened. And he has access to a mask. But what's it? Yeah. So I guess that's your point. But the volunteer fire world, I don't know. Chip, what does your department do? Do you have operator only? Can they?
I have one medical exception, and he's relatively limited, but everybody else is clean shaven. And I have a lot of clients in particular areas. Ohio has some very heavy Amish areas. And again, I was down south here not long ago when there was a great number of people that had beards. But if you're on my department and I'm in charge and ultimately responsible for your safety, you're not having a beard. It's that simple. And people who, have been away on vacation or come back, somebody shows up, here's the razor, you're going to shave that now. And they know the rules. Knows what the expectations are. You can be, I get the idea of it, especially as you said in the volunteer world, it's not your full-time job, but it's a job whose your life, other people's lives rely on your ability to do the job well, and potentially subjecting yourself to the byproducts of combustion or hazardous materials isn't good. So, I just think if we're going to be consistent, you have to enforce the rules. And as Curt has already said, there's plenty of literature that supports that position.
Yeah, but we do want to say that literature is old. Okay, and I think, like, for the folks out there, I know there's advocacy groups out there. There's racial advocacy groups that are concerned with this. There's disability advocacy groups that are concerned with this, and there's religious advocacy groups that are concerned with this. Okay, your solution is not to litigate this. In my opinion, that's not the solution. The solution is political. We've got to get the government, federal government, NIOSH, NFPA to take a look at the research again, go back and look at the modern technology and see if there has been sufficient improvements in the technology since the original studies were done, to determine whether or not that is still necessary. It's necessary to be clean shaven. Maybe with the technology, if we do the research again, maybe it'll come out differently. That's the solution. The solution is science. It's not trying to litigate this. Okay? Right. And that's my 2 cents.
I don't disagree with that. Again, from my perspective, I'm saying the literature that we have available to us says one thing, and if it changes, then again, it's my decision becomes scientifically based.
Exactly.
Right?
And right now, chiefs don't really have the flexibility to say, oh, well, you're a really important member of this department, and therefore we're going to allow you an accommodation. It's just that we don't have that kind of flexibility.
Well, and if I do start exercising flexibility, I end up with the
discrimination case decision. Yeah. But the problem is we do have some science, and maybe you guys know better than I. But every year before this, I was fit tested. I probably was right. We've all been fit tested for decades, and if I turn my head the wrong way, sometimes it pops a seal or whatever, and I might not pass, and I do it again, and I'm more careful how I turn my head. Not right. But here's the thing. I've had firefighters and I have clients with firefighters who had a thin beard and they passed the fit test. Now what do? They passed and I don't mean a big, giant, religious, orthodox, beard, but if they pass the fit test, how do you tell them?
It's in OSHA and NFPA. It's in OSHA and NFPA. It could not be clearer, even if you can pass the fit test.
Thank you.
Even if you can. Okay. So again, I think, somebody needs to go back. And again, whether it's the federal government that funds it, whether it's the NFPA, whether it's the IAFF, somebody needs to underwrite the research and, get us a definitive answer. And then the law, we're dealing with regulations and standards, but they should track the science, not emotion, not justice, not social justice. The science should dictate.
And I don't know the answer to this, and maybe we could pull it up quickly as we're rambling for the next couple of minutes, but the OSHA opinion letter that came out probably 3 years ago or so, and 4 years ago maybe, and said, okay, now we're going even to a stricter standard, 0 facial hair growth in 24 hours. Was that based on research, or is that based on we have too much time on our hands and let's put out another policy? Because what changed, and I don't remember seeing any research on that. So what changed to cause that? Because that was a really problematic, especially for, again, a lot of Black firefighters whose skin, there's a skin condition, right, in the Black community, the more you shave, the more irritated and bleeding your skin is. And that had a big effect on people. That's what created that was the focus of the Bay versus City of New York case. So what was that based on, if anybody knows? I read the letter and I don't remember seeing it based on research. I could be wrong. It was years ago.
I would be curious because
I'll see if I can find
it. It seems that time flies as I age. So I'm thinking national politics. I would like to know the year that came out. I mean, we talk about what was 2 or 3 years ago.
I think it was four or five.
Because yeah, if it was 5 years ago, I might have an explanation for it.
Right.
If it was 2 years ago, I'd be a little surprised, to be honest.
Oh, I would have been the reverse. I would think the prior administration would have more regulations and we'd have fewer. But
except if you're talking about what groups are affected.
oh,
right?
well, okay. Yeah, if you think it was racially motivated policy, which then could give you a whole new basis to challenge and it wasn't even a ruling. I think it was a policy determination, which doesn't take active legislating like it would publishing in the Federal Register, notice and comment. I think it was just a policy statement that came out, an interpretation of the rule, which takes nothing. So that's an interesting view. You might get a lot of hate mail from 50% of the people, but who knows?
I've got I don't have the letter, but I have a quote from it. It's May 9th, 2016, OSHA interpretive letter. Yeah, 2016. It's not too bad, but interpretive letter, and this is a quote from it. The Respiratory Protection Standard, paragraph 29 CFR 1910-134 G1 small I capital A states that respirators shall not be worn when facial hair comes between the sealing surface of the face piece and the face, or that interfaces with the valve function. Facial hair is allowed as long as it does not protrude under the respirator seal and extend far enough to interfere with the device's valve function. Short mustaches, sideburns, small goatees that are neatly trimmed so that no hair compromises the seal of the respirator usually do not present a hazard and therefore do not violate the respiratory protection standard.
I don't know if that's the one.
Let me see if I can find. Let me see if I can find the actual letter.
But it still begs the question: was it based on science? And I feel like we're regulating without purpose. I got it. Okay.
I got it. Well, go ahead. You keep talking, and I'll see if.
No, I'm kind of rambling, but let me go back as we're looking at this. So, look, the point of this show today is to make people aware that if you're going to, one simple point in sense, if you're going to have a class of persons that's required to wear SCBA, make sure, one, all of them have to, and two, it actually relates to their job or potential job, that they actually could end up in an ideal-age environment. To claim, well, mechanics can't get a religious exemption when they can't go to the scene, you're probably going to lose that. But these cases keep coming up. And you don't want to be defending one of them in truth. I don't know. And we're not at closing, but as we give some time to Curt, Chip, any additional comments as you nod your head?
No, I think you hit it. You hit it right on the head. The other part of this, though, and we've talked about this before, and I was thinking about when we were talking about consistency in jobs. The other thing that we've talked about before is the diversity within departments, and you have talked about in the past trying to actively recruit qualified representatives of minority communities within your greater community. I mean, so your fire department's reflective of the people you serve, and on one hand, also thinking about, well, we really want you to join our department. But you can't. You have to shave, and I'm thinking, like, does that when we talk about our difficulties on the volunteer side of trying to get people? I mean, that is part of this quandary, right? That we have everybody telling us right now, you have to shave, you can't wear SCBA, safety wise. This is what we want you to do, or you have to do. On the other hand, we're saying we really want to recruit members, and we have a hard time on the volunteer side getting them, and probably on the career side now too. So, that's one of the realities of the administration saying, I've got these two competing interests.
Yeah, and you just have to choose a look. I mean, the problem is when I do that beard, right, and I just have this, I look like a pedophile. It just doesn't work for me. So people have to choose what they want their look to be. But hey, look, if you want to have a full beard, I guess you're not joining the fire department. I think here's the problem. Most people think the fire department, especially on the volunteer side, is a community organization that's open to everybody, regardless of anything, weight, health, appearance. It's not. Right? This is not a social club. This is a job that we don't pay you for other than cool t-shirts and hats. But I mean, that's really it. And so I'm sorry, if you want to have a beard, you're just not going to be on the fire ground. That's really what it should be. Except we have one more big problem. We now require no EMS can have, right? No EMS personnel can have beards because you could be in an area. What do you do when mutual aid comes in and they don't have the same requirement? Do you kick them off? And how about even fire? What do you do?
I have.
There you go. Okay.
I have.
And you kick them off.
I have. I've sent letters saying, please send me qualified interior firefighters.
And the qualification is no
Which
beard.
Means
but what do you do with an ambulance company who shows up for rehab or EMS support?
That I'd have to think about. That's usually not in the past has not been one of my immediate thoughts because I'm not dealing with.
My answer is stick them in the cold zone, right? What determine what area is totally safe. The problem is your issue of what do you do when we have a rolled over car? We need to get the guy on the backboard, right? We bring the stretcher up. We're all in SCBA, and how many times has this happened to us? All the firefighters in SCBA because of the leaking crap coming out of the car, and EMS walks right up. We're like, what the? And the fire chief probably, but they're like, what are you guys doing? And the answer to that is you kick them off, take their stretcher, and go get the person with their stretcher, right? But you can't stick them in back of the car if we're all wearing masks and they can't. So do we now have a rule that says EMS personnel have to be clean-shaven and fit tested, et cetera, when many private and public EMS entities are not prepared for it? And I bring that up not because it's a weird hypothetical. It's going to be used against every single fire department when they say, oh, we don't let our personnel come. Well, but you allow everybody else.
I did come up with a sort of an answer. It doesn't look like OSHA said the 24-hour. It looks like NIOSH came out with a conformity document trying to explain what they were looking for. So NIOSH said 24 hours. Apparently, it's temporarily unavailable. I'm thinking Doge and Elon Musk, but there was this. You can't access the document. OSHA's looks like you can access OSHA's interpretation letters, but the Google search was taking me to a place that it says it's not available. It's been moved and is not available. So.
Wow. Well, hopefully it's not with all the, families of the minorities who fought in the war and all the war heroes. But in any event, not making a political comment. So I think we have surpassed our time, and we certainly gave hopefully everybody a lot of good thought. Let's do a quick closing arguments or closing comments, and I will simply say that I've already given mine. You treat everybody equally in the same job class, and if they have fire suppression in their activities, then they're going to wear an SCBA and they're not going to have a beard. Chip?
Same.
I love it. Curt?
You need to have good policies. You need to think through this stuff. Policies, defining those classes that you mentioned to make it crystal clear so that even an imbecile judge cannot misinterpret what is going on in a given case. And then you have to be consistent in terms of your application on it. And for those of you like myself, I have facial hair, and lots of friends of mine have beards. And let's work on the science end of it. Let's not litigate it. Let's not that I don't want to see lawyers make money, but let's solve the problem scientifically. Let's figure it out, and then we can all move forward as a solid community instead of fighting with each other over things.
One last bit: if you fail to follow our advice and you do find yourself in harm's way with a lawsuit, hire a lawyer who knows what they're talking about and understands all these issues.
Yeah, and the point of that, and I apologize for the construction noise in the back, but the point of that's really made by the fact that the main decision in this case we started talking about, is talking about the captain can waive SCBA requirements. The lawyer somehow allowed that, or maybe, I'm not criticizing the lawyer because I don't know who it is, but however that judge got
the lawyer probably didn't get it, didn't see the relevance of it,
And you can go back to, you want bad lawyering, go back to the original DC decisions.
Yeah.
Right. Those are the Washington, DC decisions. The Court of Appeals said it's bad lawyering and we're stuck with what we got.
And that is true. You got the arguments you got. Okay, well, on behalf of Curt Varone, Chip Comstock, the missing, once only in very few missing times, John Murphy, and myself, Brad Pinsky, we welcome thank everybody for watching Fire Service Court. Take care, everyone.